Yes, Mr. Zubair.
Well, I was reading Keshavnan Bharati at paragraph 620 at PDF 274. Let me finish that. So they talk of the marginal note that I was reading. And that's the language of 368 to our mind is plain and unambiguous, that paragraph. The bottom of 620 minutes. Marginal note plays a very little part in the construction of a statutory provision. It should have much less importance in construing a constitutional provision. The language of 368 to our mind is plain and unambiguous. Hence, we need not call into aid any of the rules of construction about which there was a great deal of debate at the hearing. That the power to amend under the article, as it originally stood, was only implied. The marginal note rightly referred to the procedure of amendment. Reference to the procedure in the marginal note does not negative the existence of the power implied in the article. Then they go on to say whether you can amend every part of the Constitution. We're not concerned with that. That's the basic structure of theory, so we're not concerned. Now kindly come to paragraph 1117. That's at PDF 424. 424. This is the judgment of Justice Jagan Mohan Reddy. Paragraph 1117, page 424, PDF 424. Where reference is made to Dr. Ambedkar's speech. That's a very interesting observation.
424, you said?
424 PDF, paragraph 1117. The question arose in the context that when the Constituent Assembly is sitting, we're passing this and clearing this Constitution by majority vote. And this is an unelected body. When you give that power to the Constitution, why do you need 2/3? So in that context, that was Dr. Ambedkar answers that. Lordship has 1117?
Yes.
Hello, Justice Gawai, Justice Kaul. Yes. Reference may also be made to the fact that during the debates in the Constituent Assembly, it was pointed out that by many speakers that assembly did not represent the people as such because it was not elected on the basis of adult franchise. And some of them even moved resolutions suggesting that the Constitution should be ratified by the people. Both the claims and demands were rejected. Dr. Ambedkar explained that, and I quote, the Constituent Assembly in making a constitution has no partisan motive. Beyond securing a good and workable constitution, it has no axe to grind. In considering the articles of the Constitution, it has no eye on getting through a particular measure. The future Parliament, if it met as a Constituent Assembly, its members will be acting partisan, seeking to carry amendments to the Constitution to facilitate to passing of particular measures which they have failed to get through Parliament by reason of some article of the Constitution, which the Constituent Assembly has none. That is the difference between the Constituent Assembly and future Parliament. That explains why the Constituent Assembly, though elected on limited franchise, can be trusted to pass the Constitution by simple majority, and why the Parliament, though elected on adult suffrage, cannot be trusted with the same power to amend it. How prescient words of Dr. Ambedkar. So when you are actually trying to use the legislative power, then you do it with a partisan motive because you want to get a bill passed, you want to get a particular policy through. But when you're as a Constituent Assembly, you have no such motive. So you can't convert a legislative assembly into a Constituent Assembly. Because as a legislature, your intent may be partisan. At a constituent assembly, it can't be. Well, you're not passing any law. At the final stages of the debate on the amending article, Dr. Ambedkar, replying to the objection that the Constituent Assembly was not a representative assembly, as it has not been elected on adult franchise, that a large mass of the people are not represented, and consequently, in framing the Constitution, the Assembly has no right to say that the Constitution should have the finality which Article 3 or 4 proposes to give it. Said, sir, it may be true that this assembly is not a representative assembly in the sense that members of the assembly have not been elected on the basis of adult suffrage. I'm prepared to accept that argument. But the further inference which is being drawn that if the assembly had been elected on the basis of adult suffrage, it was then bound to possess greater wisdom and greater political knowledge is an inference which I utterly repudiate. So then, Malas, that's enough for this part of the discussion. Now kindly come to Quello, volume 3.
On the other hand, the Constituent Assembly of State of Jammu Kashmir was elected.
Yes, yes.
I'm saying on the rationale.
That's right.
It should or should not be.
That's right.
It's simple. There's slight difference between Article 370 and what is stated here and what is the objective and purpose. One, there is an element of flexibility in 370. Let's not go into the fact specific how it was done in this particular matter. In the form of whether it's consultation or with prior with acceptance, incorporate and become part of it. So when we read the proviso to clause 3, at the time when the constitution was adopted, obviously there was no constitution of J&K.
No constituent assembly.
And no constituent assembly. But obviously they were aware that constituent assembly is going to come up and going to do it.
Absolutely.
So why can't we, when we interpret the constitution, because if we accept the argument that clause 3 was not to become dead after the constituent assembly had enacted or they had proposed the constitution, why can't we accept that argument that the Constituent Assembly, for the purpose of the proviso, could, in a sense, be interpreted also to include the Legislative Assembly, keeping in mind the fact that the Parliament could have very well amended the Article 370 also.
No.
Number 2, that if the objective was not to close or not to put the Article 370 in a straitjacket, which is obviously clear, it's a flexible article in the sense that you could, whether it's clause D or it's B1 or B2, you could keep on adding up to it, and the orders passed reflect that.
That's nothing to do with 370 sub-article 3. There's no flexibility there. Where's the flexibility?
So it is incorporated in 3. If we accept it's incorporated in 3, that notwithstanding anything contained in the foregoing provisions of the article, the President may, with public notification, declare the article will cease to be operative or shall be operative only with such exception modifications from such date as it may specify. Yes, the proviso puts a precondition to it.
No, it's a flexibility at the instance of the Constituent Assembly, not at the instance of Parliament. Surely, Malas.
But then, when we are reading the term Constituent Assembly for the purpose of the proviso, At that time, when it was enacted, it was in nineteen
But they
forty-nine.
contemplated it, Malaz. They contemplated it. Why would they add the word constituent assembly in 370 when it was not
Because
in
at
place?
that time, we didn't have any legislative assembly for the state of J&K.
No, correct, but you had the orders. Well, I don't understand. The flexibility at the instance of the constituent assembly, but this power is given to the constituent assembly, not to the legislature. It's not flexibility at the hands of parliament or the legislature, because 147 says there's no flexibility there at all.
So there are two parts to it. First is whether the parliament could have done it. That's a separate argument. But when we interpret the term constituent assembly for the purpose of the proviso to clause 3, can we by implication, because at the time when the constitution was enacted, at that time there was no legislative assembly for the state of Jammu and Kashmir. Is that factually correct? Answer is yes.
Yes, of course.
So then, when we interpret the term over here, can we interpret it to include the legislative assembly?
But Manas, how can you interpret a term in a constitution which says constituent assembly as the legislative assembly? I don't understand, Manas. Under what concept of interpretation of the constitution will you do that? There is no implied power. There is no express power. I mean, you can change any definition of any provision of the constitution.
That may not be, that will be it. Look, the term constituent assembly, when it is used in the proviso to clause 3, at that time, there was no legislative assembly.
For the purpose of framing the constitution that the constituent assembly is formed. That's not, Malad, there's nothing to do with the legislature, which is why, Malad, Keshavnand Bharti.
See, the explanation which has been enacted was afterwards, is sometimes in 1952. Explanation enacted and has been made part of part 1, clause 1, was probably in 1952, if I'm not mistaken.
It was there, Malad.
No, initially there.
It was amended later on. That's not, it was there, but
it was there, it was amended.
Yes,
later.
yes.
Because at that time, then the legislative assembly was brought in. Council of Ministers was brought in. Because at that time, there was
The
no
word
council.
governor, Malad, was had to be.
There was no council of ministers at that time.
That was the Maharaja, Malad. But that issue doesn't arise here. We're talking about, Malad, a constituent assembly, the power of the constituent assembly. And you have now, there are now, the Keshavan Bharti, Malad, fortunately and unfortunately sets the law.
Mr. Sibal, just as a, because we are not looking at it from that perspective yesterday, where was the first reference to the Constituent Assembly? Of course, the Constituent Assembly of the state finds a reference in the Constitution itself in Article 372.
Yes.
370(2). Where is the first reference to the Constituent Assembly in the documents which you read out to us yesterday prior to the Indian Constitution? I find that in the proclamation of the Maharaja.
Malad, they are in the constitution debates, Malad.
I find that there's also a reference in the proclamation of the Maharaja which we read out yesterday. The reason I'm asking is this.
It's probably there, yes.
Sorry?
Karan Singh's proclamation, I think.
Yes.
Huh? I've already mentioned that in the Constituent Assembly debates. Iyengar, Malad, your lordships will remember.
Yes.
I quoted Malad's sentence.
Yes, volume 8.
All there, Malad, yes.
Page 117. Yeah, Mr. Gopal Swami Iyengar's.
All there, Malad, yes.
No, because when the Maharaja made the proclamation, when the Maharaja issued his proclamation on 5th of March 1948.
It was contemplated by the Constitution and the Constitution makers that there would be a Constituent Assembly which would come into place, which happened in 1951.
Right.
That's what happened.
What happened first was that when the Maharaja made his proclamation in 1948, he spoke of a National Assembly.
Yes, absolutely.
Right? He says, my Council of Ministers shall take appropriate steps as soon as restoration of normal conditions have been completed to convene a National Assembly based upon adult suffrage. Then 5, the Constitution to be framed by the National Assembly
Yes.
shall provide adequate safeguards for the minorities and contain appropriate provisions guaranteeing for the freedom of conscience.
Right.
Now, what appears to have happened was that before elections were held, by adult suffrage, they composed the Constituent Assembly. That's how the Constituent Assembly
Yes.
came into existence. Now, your whole argument is, of course, that, what is to be done by a Constituent Assembly cannot really be done by a Legislative Assembly, and therefore less so by the central government assuming the character of a Legislative Assembly under 356. That's the... what happens then if there is no Constituent Assembly?
I'm sorry, Malad?
What happens if there is no Constituent Assembly? Do you have to create a Constituent Assembly afresh?
Malad, that is precisely between 1948 consultations, Malad, your lordship will
No, now what would happen? Suppose they keep aside the procedure which they followed. We're keeping that aside for a moment.
Correct.
373 postulates the Constituent Assembly has to give its
Right,
recommendation
right.
on any proposal for abrogation.
Right.
Suppose the president were to move a proposal for abrogation. According to you, how would that be effectuated now, say in post-1957 India?
So, Malad, let me answer that in two parts. Malad. Number one, what my lord is putting to me is in 1948, they contemplated a National Assembly.
Right.
But your lordships must remember that those were years between 1948 and 1950, especially after 1947, after the instrument accession was signed, Malad. After the instrument of accession was signed, those were transitional periods. And when the constitution came to be framed, there was a dialogue between the state of Jammu and Kashmir, as it then stood through the Maharaja, and the government of India. And both of them decided that we will put this into the constitution, that is 370, use the term Constituent Assembly, and you will then set up a Constituent Assembly to frame the constitution and decide what you want to do. You must understand the historical context in which this happened. This has not happened in an isolated fashion. Malad, the Parliament of India, the Constituent Assembly in India, framed a constitution which included a provision for a Constituent Assembly of Jammu and Kashmir. Malad, surely that was not an isolated act. This happened in consultation and in agreement with the then Maharaja.
And the J&K Constitution contemplates that this Legislative Assembly will have no role in regards to the amendment of the provisions of the Constitution relating to Article 370.
Otherwise, they would not put that phrase.
But then how would that, what sort of a...
Next question is, supposing there was no constituent. That's the next
How
question.
do we, then what
Well,
constitutional
if there was no
mechanism would be envisaged then?
If there were no constituent assembly and your lordships were sitting in 5, I would have answered that question, but luckily we have a constituent assembly. Because I can't answer a hypothetical question as to what would
How
have
would you then put into place the constitutional machinery? Because there has to be machinery. It can't be that, because there is no Constituent Assembly, because there is no Constituent Assembly, you cannot at all deliberate on a proposal for abrogation or modification of Article 370.
Your lordship is putting to me, supposing the Maharaja refused to have a constituent assembly.
No, take 2019.
I'm sorry?
Take 2019.
Yes.
When the Constituent Assembly has been convened, the Constituent Assembly has drafted the Constitution.
Yes.
Therefore, its role has come to an end. There is no Constituent Assembly.
Correct.
2019, the government wishes to, the president wishes to modify Article 370.
Yes.
Now, we've seen the process which they followed.
Yes.
What, according to you, would have been the constitutional process to...
No constitutional process, because the Constitution of Jammu and Kashmir said in terms in 147 that no such bill can be introduced in the legislature.
Oh, by them.
By them.
I'm talking about, no, by them, where the constitution as it applies to the state of Jammu and Kashmir, which is part of the law applicable in Jammu and
So,
Kashmir.
according to you, no constitutional procedure
No.
shall be initiated for abrogation of Article 370 at all.
I've been saying it's permanent. Why do you, Mullah, I've been
The
saying?
argument is that after 1957,
Yes.
the president ceases to have any power under Article, sub-Article 3
That
of Article.
was temporary between 1951 and 1957. Where do you get that power from? You see, the point is, Malaj, at that time it was temporary because there was nothing in place.
After 1957, sub-Article 3 has become OTOs now.
Yes, no, Malaj. It can happen as a political decision. The Jammu and Kashmir government and the legislature of the state unanimously did what, and they merged. That's another issue altogether.
So, Mr. Sabal, according to you, neither the assembly can do it,
Yes.
nor the parliament can do
Yes.
it.
Yes.
What you are saying is, while other provisions of the constitution may be capable of amendment through a process envisaged for amendment,
Yes.
other than, of course, if it is hit by basic structure,
Correct.
this is one provision which can never be amended.
And let it put it differently, but let me put it, under what power will this take place? Let's assume, they can do it. If my lord
I'm just
put the
thinking
question to
aloud.
me,
To have a
under
pers-
which provision of the constitution can they do it?
Having a permanency, the whole concept is that constitution is also a live document. At some stage, can we say there is no mechanism whatsoever for ever changing it, even if everybody wants to change it, and it doesn't affect the basic structure? Then to say that if suppose all of Kashmir wants it, hypothetically
Then
saying,
a political act can be, but there can be a political act.
And,
I'm sorry,
and those negotiations,
Clause 1 is the answer to this. 370 clause 1, bit by bit modifications, exceptions, applications have come. Now, if, and one important thing your lordship may note is it's completely irreversible. Because it's completely irreversible, all those parts which have now been brought in, they cannot now reverse. So part 3, for example, have come in with
Can
modifications.
Parliament not have amended the constitution exercising the 368 power to abrogate 370?
No.
Which means therefore that there is a provision of the constitution, apropos what fell from Brother Justice Call, that according to your submission, there is a provision of the constitution which lies even beyond the amending power of Parliament.
That's right.
Your lordship may note
So
what
we are creating then a new category apart from basic structure.
No, not
That 370 belongs to that.
It is inherent and it's integrated into 370 itself. It's not a new category. It's a category that exists.
370 clause 3 only provides that if you want to abrogate, there is a mechanism for abrogation, which is why it's temporary. Now, if 370 clause 3 goes and is not brought into service, 370 clause 1 can now be used continuing with the legislative assembly, with the government of Kashmir, giving its consent, and the entirety of the constitution can be made applicable to Kashmir still under 370 clause 1. It can still be done. So the answer is not that it can't be done.
I'm sorry.
Let's assume
Is it-
what your argument on clause 3,
Is
which has
allowed.
been argued that clause 3 is today etched in stone, is now, it cannot be.
not done.
want to put
Yes,
is
yes.
that 371, according to 370 sub clause 1, itself envisages bringing in different provisions.
Correct.
Tomorrow, through that process, it is said that each and every provision of the constitution applies to the state of JNK.
Yes.
Then what remains of 370?
Nothing.
Then the only,
To say that you can,
It can
in
be
a
taken.
sense, make completely 370 infructuous, yet it is sacrosanct where it can never be removed.
Let me just explain, Manoj. Clauses 1 and 2 and 3 have to be read together. 2 is transitory. 3 provided for abrogation to be temporary. So if you have a constituent assembly and they are giving their recommendation, then the abrogation was immediately possible. It's a shortcut and 370 comes to an end. The long way around is through 370 clause 1 with applying provision of part
So I'm
1.
saying therefore said that
Yes.
371, according to you,
Yes,
can mean, orders have been issued from time to time.
yes.
That it can say that each and every provision of the constitution.
It can, of course.
Correct. Once we come to that,
Yes.
I'm just thinking aloud. What remains in 370 after that? Which means
So
you are saying the shell of 370 should remain, but the substratum can
we are
be.
saying that assimilation needs to follow the correct procedure. The 370 clause 1 procedure is still available, was what we are arguing.
I don't know what
It's
he's arguing, but it's certainly not what I.
This is what we are saying.
Yes, Mr.
That-
Yes.
That may be his
The
interpretation.
expression.
I think, let Mr. Sibal come, because, otherwise that'll, I think, Mr. Sankarnaran, what will happen is, we are following a certain line and a link and a syntax, so, I mean, I think, we might be broken up in the nuance of.
Because, respect Mr. Sibal, he knows the law. We also therefore didn't jump and answer the questions.
I don't think.
See, the nuances are so many as something Mr. Sibal is arguing, something which you propound to do so. Mr.
Yes, he
Dwivedi
can.
said, no, this is not what I'm saying something different. So we'll have to see where the call, right?
You
I
can't say
understand. So
something
your
different. There's no
argument I've
issue at all.
understood at your own turn. He says that you can keep the shell, but the process is to 370 and
So there is another interpretation.
The problem is that if there's a constitutional process to do it, it can be done. If there is no constitutional process to do it, then it has to be a political act.
He's
So why
saying there
not-
is a constitutional process by which it can be done under 371.
No, you can't do away with
Okay, I-
370 sub clause 3.
No, suppose, after all, orders have been issued from time to time, bringing different provisions of the constitution in
Right,
force.
right.
Can you not say that another order be issued that it can under one saying that all the provision of the constitution apply and list them all of them and say all of them apply?
You know, the problem there is if you say all of them will apply, it applies to what? The concurrent list and the instrument of accession.
Mr. Sibal,
It doesn't apply to the other parts.
insofar as clause D is concerned,
Yes.
there are no limitations. If you read it, much of the provisions of the constitution shall apply in relation to the state subject to such exceptions and modifications as the precedent may by order specify.
Correct,
This is governed by second proviso,
correct.
provided further that no such which relates to matters other than those referred to in the last preceding proviso shall be issued except with the concurrence of that
Yes.
government.
Yes.
The treaty of accession, defense and commerce
That's
and so on.
correct, that's correct.
So if-
And the lists involved there.
And the list involved.
Correct,
So suppose if the parliament
yes.
decides to make the entire provisions of the constitution applicable to Jammu and Kashmir. Limitation under clause D.
Yes, there is. That's the point I'm making, Malaz. Because the structure of 370 and in the context of the legislature of Jammu and Kashmir is that the residuary power remains with the state.
Because the distinction is that insofar as those powers
Concurrent
under-
list and instrument of accession are two separate things, but there's no issue there. They can do it, both under 371, no issue.
insofar as instrument of succession, those
Only
entities are
four- only
concerned,
four items.
Their only requirement is consultation. Consultation.
That's correct.
Insofar as the clause D is concerned, the requirement is more stringent and concurrence is required.
That's list 3, Malaz. That's concurrent list. Residuary power is always with the state. That's the problem. That can't be done by any process. Even under 370 sub-article 1. That's the problem. But I see the point that my lord is making, that look, once the Constituent Assembly is over, then of course there's a status quo, it can't be changed. This is what my lord is putting to me. Yes, there is, but then we have to find a constitutional procedure through which it can be done.
Not amount to equating it with the principle of basic structure itself, that it can never be done. Like you cannot, and that also through a judicial pronouncement,
No,
the
but
philosophy of
Let's
basic structure.
all right, let's not talk of 2023, Madad. In 1950, what was the position? This was the position. That it can't be done.
No, but prior to the basic structure doctrine itself, it could be done. Parliament,
no,
how can
this-
we say that Parliament could not have exercised its plenary amending power
This is not basic.
to abrogate Article 370?
This is not basic structure, Madad. This is a compact between one sovereign and another engrafted in our constitution. It's a constitutional compact.
Then what happened?
Unlike other states where Junagadh, Malad, he didn't agree, you know, as a political act, you took over Junagadh. He ran away, the Maharaja ran away,
But
Malad.
that, Mr. Sibal, there, I think we are treading on thin ice, because the moment we say that this was just a recognition, this was a recognition of a compact between one sovereign state and another which forms a part of our constitution, then such a sovereign compact is capable of being overridden
That's all right, Malad. So then we could.
by the sovereign of the succeeding state.
That debate is a separate debate which doesn't arise in this case because there's a procedure that they have followed. That debate doesn't arise here, Malad. We're not talking of that at the moment. That's not an issue. We're talking about a procedure in terms of 370, which they followed, consistent with the interpretation of 370. Having taken that position that we need the consent of the Constituent Assembly.
Is this the Constituent Assembly according to you?
Yes,
Yes.
that's right. That's the procedure.
That we've
only
appreciated that
on that.
submission. Yes, of course, we have appreciated that
We are
submission.
limited only on that.
That the
Large-
process, in other words, your contention is that the process which the government of India followed assumes that the proviso to clause 3 applies,
Yeah,
that this change has to be brought in through a Constituent Assembly.
correct.
But this was evidently not the Constituent Assembly because A, it was the Legislative Assembly that you have invoked, And to even that legislative assembly was dissolved and ultimately Parliament was exercising that power in the 356.
Now, the larger question, supposing your lordships were to say this is not the right procedure, then the question will arise, can they do it through any other procedure? Then what my lord is putting to me may arise. But we're not on that issue. We're not giving solutions to the other side that you can do it under 370. I don't know where that comes from. So that's, there's a limited constitutional issue before you, which is the process, the power and the process. The power is in 370 sub-article 3. The process is what they followed. Can they do it under 370 sub-article 3? And is this process right? That's the limited issue that your lordships have to decide. If there are other processes available under the Constitution, if they follow them, maybe, but that may be valid, may not be valid, but I can't answer that question in a vacuum. And my lord is right. What my lord is putting to me, the problem is the residuary power is with the state, and I've shown your lordships, Mullad's provision after provision, right from the Delhi Pact in 1952, that that's the case.
But then what happens to Article 363A?
350?
363A. Because that also earlier the recognition was on the basis of the pact between the various princely states and.
Different, Mullah, those pacts were there, recognition granted to rulers, but Mullah, either they completely assimilated themselves into the union and be part of a state, or they were taken over. Either Hyderabad or Junagadh.
On the basis of certain agreements between the states and the princely
Correct,
states.
but those agreements were different from this agreement. Mullah, your lordship is right. If it were that kind of agreement, then your lordships would apply those standards and those principles and those judicial dictums which your lordships apply. We're not on that.
Here your argument is that unless the views of the entire populace of the Jammu and Kashmir are taken into consideration, the abrogation of 370 can't be
Yes,
such
that can be done. But that's
then the negotiations were not between the elected body. The negotiations were
because
the princely state and the union.
Correct, and that was accepted. That very thing was accepted by the then constitution makers. So, whereas we can't go into.
So if what was accepted, insofar as the other states are concerned, it could be taken away by 363A.
Correct, but that was not the position as far as Jammu and Kashmir is concerned. I'm not saying anything. I agree with what my lord is putting to me. But how do you change the constitutional structure? There must be some power. You can say that you can do a political act. Today you say, look, forget about all this. We take over Jammu Kashmir. Fine.
363A was done under 368.
Yes, you can do that. But point today is, Mother, that's not an issue before you. You're not going to answer an issue which is not, with respect, the greatest respect, which is not before you. You're not going to find a power for them which doesn't exist and which is not followed.
Yes, Mr.
I'll go back. I understand, Mullah, the difficulty, and I understand, Mullah, the fact that at some stage or the other, this had to be, let's put it this way. This had to be done. Let's put it this way. Somebody said this has to be done. So then Mullah, there must be found a constitutional way of doing it. I'm not saying there are.
It has to be done, I would say, but whether it could be done or not.
No, not
That
could
means
be.
the mandate. Question is, you say it can't be done.
No, I say this was a political act. I don't say anything more than that. This was a pure political act. And you circumvented the provisions of the Constitution to reach a particular end result, which you always wanted.
That's the second part is that, which you will argue, of course, that the
Yeah.
process by which they followed was.
Yes. Well, that is the issue before you. There's no other issue before you.
According to you, this could have been only done on the recommendation of the Constituent Assembly. Absent a Constituent Assembly, you cannot exercise the power to abrogate.
Number one. Number two, in any case, it is they who believed that this could only be done through the Constituent Assembly. Apart from the fact that I say that it could be done, they also believe that it could be done, and they followed that procedure. Now, whether that procedure was right, was wrong, is for your lordships to decide. Whether there is another way to do it is something that they will decide. That's all that I can say. I don't want to make the argument in a hypothetical argument, conjuring up issues that don't arise in this case. And I don't want to give a helping hand as my learned colleague wants to do, because he can do it outside the court.
The lighter side, you said if you had to do it, you would do it a different way.
Maybe. But you can't introduce a bill in Parliament at 11 o'clock, pass a resolution without anybody knowing about it. Of course, those are internal procedures.
You're the Parliament.
I'm not saying anything.
Article 212.
Yeah, so I'm just saying, 11 o'clock,
Or as
nobody
a-
knows. Nobody knows.
Larger issue, as a member of Parliament, you will say, don't touch us.
Yes. That's right. So I'm not touching that process either. I'm only saying that this is what, it sort of fits into the argument that this is was a political process carried through certain constitutional means, which unfortunately were not available.
Always a political process, Mr. Sibal. Only question is whether it is within the constitutional means or not.
That's right.
Everything is a political process.
No, I'll tell you how, Manoj, because now let me just go through Coelho and then I'll go back to the list of dates.
Yes.
Volume 3.
You want us to read what now?
Volume 3, Manoj. Page PDF 323. And the fact of the matter is, Manoj, apropos what my learned friend said, almost all the laws applicable in the Union of India were applicable in Jammu. As of today, Manoj, I have a list, it runs into, pages after pages. Everything has been adopted, apart from other than the residuary power. Everything is adopted. Everything. It's like 100 and...
You are referring volume 3?
Yes, volume 3. Volume 3, PDF 323. Case law, volume 3. Yes.
No, there is a separate volume for,
Case law volume.
Yes, sorry, Miller, case law volumes. Yes. It's Coelho, Miller.
Coelho and Rameshwar Prasad, they are in one volume.
Yes, leading Coelho, para 54, PDF 323. 323. Running page 776, Mother. Yes. 323, para 54. And remember this, if you use 368, you'll have to have 2/3 present and voting. So you don't use 368 because you don't get 2/3 present and voting. So you go through this procedure. So the question whether 368 could have been used or not is a separate issue. And had that been used, we'd have had another argument here, but it's not an issue here.
Yes, Mr. Gandhi. Which
I'm
is
just
the,
telling you
which
the
is the
hurdles
para
in the
from Coelho that you would like us to see?
Yes, para 54.
At page?
page 776, Miller's PDF 323.
Page 323.
Yes. The distinction is drawn, my lord has that paragraph? By the author between the making of a constitution by a constituent assembly, which is not subject to restraints by any external authority, as a plenary lawmaking power and a power to amend the constitution. A derivative power derived from the constitution and subject to the limitations imposed by the constitution. No provision of the constitution framed in exercise of plenary lawmaking power can be ultra vires because there is no touchstone outside the constitution by which the validity of provisions of the constitution can be adjudged. The power for amendment cannot be equated with such power of framing the constitution. The amending power has to be within the constitution and not outside it. Why? Because you're subject to the constraints of the constitution. So you want to amend, you can use 368, but then you have to follow the procedure under 368. But so, for example, if you were to say that you amend the definition and say the provision for consent of the states is not required. Approval of the states is not required. Can you do that? The answer is no. That's a proviso to 368. So if you want to work within the constitution, you have to follow then what the constitution obliges you to do constitutionally. If 368 were available.
All right, apart from Coelho, which is the next?
Yes, next is para 118 of Coelho itself.
PDF?
PDF page 344. We have I'm sorry, para 180. We have earlier noted that the power to, my lords have that?
Para 118.
Yes. We've earlier noted that the power to amend cannot be equated with the power to frame the constitution. The power has no limitations or constraints. It's a primary power, a real plenary power. The latter former power, however, is derived from the former. It has constraints of the document, that is the constitution which creates it. This derivative power can be exercised within the four corners of what has been conferred on the body constituted, namely Parliament. The question before us is not about the power to amend Part 3. As per Keshamnan Bharti, power to amend exists in Parliament, but it is subject to the limitation of the doctrine of basic structure. The fact of validation of laws based on exercise of blanket immunity eliminates Part 3 in entirety. Hence, the rights test as part of the basic structure doctrine has to apply. So, Malats, therefore, we are now left with a Parliament which seeks to amend 370. So, therefore, it has to work within the constraints of the Constitution. That's what we're concerned with. We're not concerned with any other interpretation of the Constitution. So now we go back, Malas, to the list of, yes, the Ambedkar statement is volume, yes, document volume 8, PDF page 26. Yes. Volume 8, documents volume 8, PDF page 26. Malas, quite frankly,
PDF page?
26. Just two paragraphs, and then I'm done with this issue altogether, Malas. PDF page 26. Documents volume 8.
Eight.
You also have it, may I read it, Manoj?
Page?
Page 26, paragraph starting the provisions relating to amendment of the Constitution. My Lord Justice Surikant has it.
Yes.
My Lord Justice Cole has it.
Yes, yeah, right.
The provisions relating to amendment of the Constitution have come in for a virulent attack at the hands of the critics of the draft Constitution. It is said that the provisions contained in the draft make amendment difficult. It is proposed that the Constitution should be amendable by a simple majority, at least for some years. The argument is subtle and ingenious. It is said that this Constituent Assembly is not elected on adult suffrage. Well, I've read this part of it I've read.
We actually read it from just Jaganmohan
So
Reddy's
let's leave that. Come to the next paragraph.
Sorry, Hegde.
What is said to be the absurdity? That paragraph, next paragraph.
Yes.
What is said to be the absurdity of the amending provision is founded upon a misconception of the position of the Constituent Assembly and of the future Parliament elected under the Constitution. The Constituent Assembly in making a Constitution, well, that also I've read. So this is the exact.
There's only one part in Dr. Ambedkar's statement which is very prescient. Dr. Ambedkar postulates that a future Constituent Assembly may be a future Parliament itself.
Yes,
Says the future Parliament, if it met as a Constituent Assembly,
yes,
its members will be acting as partisans, seeking to carry out amendments to the Constitution
yes.
to facilitate the passing of party measures which they failed to get through Parliament by reason of some article of the Constitution, which has acted an obstacle in their way.
This is
That
the
is
precise
difference between
argument.
the Constituent Assembly and the future Parliament.
So this is the precise argument I'm making is what Dr. Ambedkar said. That it is the party's partisan political measures that are carried through in the process in the form of legislation or otherwise, which can't be done as far as which will be constrained by the provisions of the Constitution, but the Constituent Assembly doesn't have any such fetters.
Yes.
So, Mullahs, I'm done with this whole argument, Mullahs. So now let's go back to the list of dates and how all this happened, the other issues. No. Now compilation.
We go to
In my written submission.
your written submissions, volume
Written
2.
submissions, volume 2. And kindly come
Page
to
48.
page 47. Yeah. Huh? Yes, where is that? Yes.
These are
Now-
list of dates.
List of dates kindly come to
Volume
PDF
written
47,
submissions.
item 57.
Submissions. Yes.
Item 57, PDF 47 in my list of dates, volume 2 of the written submissions. But it's 20th of June, 2018. Section 92.
That we saw, Mr. Sibal.
Yeah.
That we saw, you read out section 9.
That's right. No, but what's important is the date. On the 19th of June, a political party in coalition with another party, which was in government, withdrew support.
That is not in a list of dates.
Yes, just kindly note that. It's in the proclamation.
19th of June 2018.
Yes, well, it's BJP withdrew support from PDF.
This is
PDP.
Before the serial number 57, no?
Yes, yes. It's in the document, but I just wanted to. It's the proclamation. Let's see then.
Yes, Mr. Sibal.
Now, so he issued, the governor on the next day issues a proclamation, which is also quite curious.
That we find at top of page
That
48.
your lordships may look at, PDF page 85, volume 3, the proclamation itself.
Anything turns on it? I mean, in the sense to read it. I mean, you've paraphrased it, I guess.
Yes, I have paraphrased it.
Is there any
No,
particular
nothing.
sense?
The provision
Not
permitted the
necessary.
governor by proclamation to assume to himself all the powers and functions of the government of the state. Such a proclamation in one terms of 92(5) required concurrence of the president, and under 92(3) would cease to operate within 6 months, which I've already mentioned to your lordship. We need not go into.
This is the power corresponding to 356, which is vested in the governor.
That's right. That's right. But here it's vested in
The
the
governor.
governor, independent of the council of
Of the
ministers,
council.
which I mentioned to your lords. It's a very, very unique power. And the council of ministers was suspended in the process. Well, he didn't even wait for a day. I mean, is normally speaking, what would happen? Malas? A governor would wait for other political affiliations to take place to form a government.
That's also part of political process.
I'm sorry?
That's also part of political process.
That's precisely what I'm saying, Malas. But why do you think I've been saying this? Why would a governor do this on the next day, Malas?
Yes, then what happened?
Well, then, so he does this, so 6 months were to expire. Then, there is some controversy, and I just tell your lordships orally that controversy is. According to the PDP, and I think somebody else will argue that, I'm not arguing. According to the PDP, they send a fax to Srinagar that they have the support of the National Conference and they are willing to form the government. The governor says he never received the fax, because he says that he was in Jammu and the fax was sent to Srinagar. So Malas, on the 21st of November, the next day, he dissolved the assembly. Yeah, on 21st November.
The facts of some
Fax is also
constitution
sent on
benches have a
21st.
sense of deja vu, no?
Fax is sent on 21st, he dissolves it on 21st. The fax hasn't reached him. Fax was sent.
It's almost on the annual of the period expiring.
No, that expired on 3rd of January, 19th of December.
19th, so about a month short of
Yes,
that.
yes, month short, Malas.
This is
Because-
not under challenge anymore.
No, no, I'm not,
that's
I
not-
myself said so. I myself said that that is an issue which.
So he dissolves the legislative
He
assembly.
dissolved the legislature. Now, Malas, you can't dissolve without the council of ministers. 36, 38 and 92 are his only powers. He has already suspended the council of ministers. He dissolves it,
Without the aid and advice.
nothing. Why do you think I've been saying continuously that this is a pure political act? The governor and the government were acting in tandem. They wanted to get rid of 370. Toss it out. Why would any governor do that? Why would the governor on 20th of June, after withdrawal of support on 19th of June, suspend the assembly? Don't allow any political affiliation and parties to take place so that a new government can be formed.
Which is the power of dissolution under the constitution, just for the cross.
Yes, 53. Section 53 of the Constitution of Jammu and Kashmir gives that power of dissolution, not part of the exception given to the governor with reference to his powers that he can exercise without the aid of the Council of Ministers.
Yeah, because section 35 refers to 36, 38 and 92.
36, 38 and 92. The process, according to me, when you're interpreting constitutional provisions, is as important as the substance. Because it's a constitutional process.
That's what another Coelho says, but this time it's Paulo Coelho in The Alchemist.
That's right. Then, Millet, on the 19th of December, the proclamation of governor's rule expired. A proclamation under 356 promulgating president's rule in the state of Jammu and Kashmir was issued on 19th December. So then came president's rule. So on 3rd of January, want to show the proclamation? Well, it's better to see the proclamation, volume 3, PDF 92. Volume 3 of documents, PDF 92.
You want us to look at this, Mr. Sibyl?
PDF?
So you want to?
Yes, I do. Let's see that, Malad. It's important. Because that's a very important provision. It has huge implications as to what happened later. My lords have PDF 92.
PDF?
92, Malad. Volume 3 of the document. Justice Gawai, Justice Kaul.
Yes.
Justice Surikant.
Yes, it seems.
Yes.
The following proclamation by the President is published. I, so and so, have received a report from the Governor of the state of Jammu and Kashmir, and after considering the report of, and other information received by me. Well, it's all Governor's rule. Kindly see, Malad. It's all Governor's rule from 20th of June right up to this date. There is no Council of Ministers in place. There is no government in place. But he sends a report that the government cannot be carried out. Where is the basis for any of that? There are no negotiations. There are no communications. So he says, I am satisfied that a situation has arisen in which the government of the state cannot be carried on. Government of the state, but the government of the state was carried on by the governor. In accordance with the provisions of the Constitution of India as applicable to the state and of the Constitution of Jammu and Kashmir. Now, in exercise of the powers conferred by Article 356 and of all other powers enabling me in that behalf, I hereby proclaim. Kindly come to C. A, assume to myself as President all the functions of the government of the state and all powers vested in or exercisable by the governor in that state under the Constitution and the state constitution. Declare that the powers of the legislature of the state shall be exercisable by or under the authority of Parliament. Now, this is important, Manoj. Therefore, Parliament will be exercising the powers of the state legislature. And the state legislature under Malad's 147, you can't move a bill. Which is what Ambedkar said, which is what Keshav Nand said, that you can't do this. You have to be confined to your powers and responsibilities under the Constitution under which you're acting. So, declare the legislature of that state shall be exercisable by or under the authority of Parliament, make the following incidental and consequential provisions which appear to me to be necessary or desirable for giving effect to the objects of the proclamation, In exercise of the functions and powers assumed to myself by virtue of Clause A of this proclamation, as aforesaid, it should be lawful for me as President of India to act to such extent as I think fit through the governor of the said state, the operation of the following provisions. Now, this is very important, of the Constitution and of the state constitution are hereby suspended. Under what power? So much of the first proviso to Article 3 of the Constitution as relates to the reference by the President to the legislature of the state, and the second proviso to that article, so much of Clause 2 of Article 151 of the Constitution as relates to laying before the legislature of the state of the report submitted by the governor, by the Comptroller and Auditor General. Now, what they did was they took away the proviso to Article 3. Under what power? You can't amend the Constitution in virtue of your power under 356. Now, let's see what the proviso to Article 3 of the Constitution says, Mothers. Kindly have a look. Kindly give it. Volume 1. Constitution, Volume 1. Documents, Volume 1. PDF page 186. Sorry. 65? PDF page 65. Yes, yes. Yes. One second, hold on. So PDF page 65. This is an amazing piece of handiwork. It's a mosaic of illegalities. Attractive enough to be junked. I don't understand how this always happens. There must have been great constitutional advisors, Mulats, who would have thought of this very complicated handiwork, which found itself in our Constitution. Bloody hell. So totally, so I wrote it now.
Right, right.
So Article 3, Mother, document volume.
So they delete effectively the proviso to Article 3. But, Mr. Sabal, at the end of it all, I mean, of course, this has the optics about the way it was done. But there's no challenge to anything that was done. All this is not under challenge here.
No, Malas, all once you are challenging the emergency, Malas, the declaration of 356 is challenged. Malas, just look at
What is
it.
the frame of the petitions? Do we have a challenge to
Yes,
the
we have one challenge. But Malas, quite apart from that, you're looking at Malas, it's in
Yes.
grade 370, Malas. I mean, it's not. we-
All right, we just see what the frame of the challenge. If you can just ask one of the juniors
I'll
to
do
make
that.
that little
I
tabulation
do
for
that.
us.
But apart from that, Malas, this is now before you
Yes,
in all its various
Nuances
avatars, in
and-
a sense.
yes, of course.
Now, the question is, Malas, what is the power? And that's the other thing. What is the power under 356? The quintessential object of 356 is to restore democracy. You take over because a government cannot be run in accordance with the provisions of the Constitution for a temporary period for the restoration of democracy. You don't use 356 for its decimation. You can't amend the provisions of the Constitution under 356. Of 356. We'll give it on Tuesday. We have to show the Constituent Assembly.
Require ratification by the state legislatures. Now, suppose a particular state, the legislature, the power has been exercised under 356 and the president assumes the powers of the legislature, the executive. Can a ratification be done under 356 in relation to that particular state legislature?
No, Malas. No, because he's exercising powers as a state legislature, Malas, in this sense. There is no question of ratification.
Not in the J&K case. I'm
Yes.
just theoretically, I'm saying, can a,
Generally, what is my lord is putting to?
some constitutional amendments under the proviso
Yes.
require a ratification.
That's right, that's right.
Now, for the purpose of computing the majority, computing the strength required for ratification,
Yeah.
can the center fall back upon the exercise of the 356 power? Say that, look, we have ratified it because we were exercising the power under 356.
Tough question.
Has
What
never
my lord is
happened, but
putting to me is that if Jammu and Kashmir, in a 368 situation, if Jammu and Kashmir were to ratify it, then Parliament can exercise that power.
Suppose any Indian state,
No, Malad.
you require a certain number of states.
Provided, Malad, the 356 is imposed there, not otherwise.
But if 356
Yeah.
is imposed, then can that power to
That's-
ratify the
that's a tough
amendment be
question.
exercised?
That's a tough question.
Even that is a little.
Yeah, it's a tough, I can't answer it.
yeah,
right
even
away.
I-
I'll have to think
just-
more about it. Because the ratification is of the state, therefore there are two separate constitutional authorities. One Parliament passing the law and
And then the
another
state.
authority ratifying it. You can't take the position, that's like, it takes two hands to clap. It's the same analogy. Therefore, you can't exercise that power yourself because that's power constitutionally is provided for in another institution, in another constitutional body.
Now here the proclamation comes under 356.
That's right.
After that, what is done then?
Then, Malad, they amend section, Article 3.
We saw that.
Yes, but Malad, kindly see, just read Article 3 with me for a minute. Formation of new states, alteration of areas, boundaries, or names of existing states.
Amendment to Article 3 required as part of this whole process.
Because they wanted to get rid of this proviso, Malad, otherwise they wouldn't have
Let's
been
see the
able to.
proviso.
Yes. Because then you have to do the Reorganization Act.
Or the reorganization.
Yeah, that required.
Converting the state
Yeah,
into a
that's
UT.
right, that's right. That's how this had to be done earlier. Second proviso is not your lordship's document, that has been the other document. The second proviso relates to Malads as applicable to the state of Jammu and Kashmir. Kindly have a look at that. Kindly just show that document.
Document volume 1.
Volume 1.
Of the order passed,
Yes. There the proviso is there.
there the proviso was,
That's correct.
that proviso is deleted.
That's correct.
Which is that proviso?
Which requires, I'm going to show that to your lordship. PDF page 65, document volume 1.
That was,
Yes.
that must be pursuant to the presidential order.
Correct, absolutely right.
So the presidential order was not, was the presidential order amended? No.
No. That's interesting.
It has been superseded, my lord.
It deals with the second proviso. You can't even introduce the bill, forget about anything else.
Or only one second proviso.
Second part of the first proviso and the second proviso.
Where do we get this document? Actually, it's document number, document compilation.
Documents volume 1, PDF 65.
65.
Constitution of India as applicable to the state of Jammu and Kashmir.
At page?
PDF 65, running page, Malads, is 65, also 65.
That's the Constitution of India is applicable to the state of Jammu and
That's
Kashmir.
where the only place where the pages of the Constitution of India and the Constitution as applicable synchronize, Malads. The rest is,
I interestingly read the note below. It says when secular was inserted into the Constitution,
yeah.
it was never inserted here.
I see. Never inserted, okay.
Just see the note below
I
it.
got
Note,
it, I got
note 1, you got it?
Yes, I got it at the bottom, yes. Socialist secular.
Socialists agree.
But see, Malads, what they've done.
Where is the proviso?
Proviso, Malads, at page 66, next page.
Second proviso.
Let's read the whole, Malads, it'll be better
Yes.
if we read the whole, if you don't mind.
Yes.
Formation of new states and alteration of areas, boundaries, or names of existing states. Parliament may by law form a new state by separation of territory from any state. But this is also be important when you deal with the Reorganization Act. You might as well read the whole article once. Parliament may by law form a new state by separation of territory from any state, or by uniting two or more states or parts of states, or by uniting any territory to a part of any state. Increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the name of any state, provided that no bill for the purpose shall be introduced in either House of Parliament, except on the recommendation of the President, and unless, where the proposal contained in the bill affects the area, boundaries, or name of any of the states, the bill has been referred by the President to the legislature of that state for expressing its views thereon, which within such period as may be specified in the reference, or within such further period as the President may allow, and the period so specified or allowed is expired. That's why, Malas, when the views of states was taken, Malas, they said, no, you haven't referred it. We said, only need to take your views. We don't have to take your consent or your concurrence. So we may not agree. Even if you express your views that it should not be done, we're not bound by it, which is the correct constitutional provision. Then the second proviso, provided further that no bill providing for increasing or diminishing the area of the state of Jammu and Kashmir, or altering the name or boundary of that state, shall be introduced in Parliament without the consent of the legislature of that state. So you can't even introduce it. Here by 356, you do away with it.
They have created a UT. Otherwise, they have not altered the territory, have they?
No, they haven't.
No.
Ladakh is not part of the state anymore.
That's what they carved out a UT and
Yeah.
made another UT, which they say.
They have carved out a UT saying that this will become a state,
Yeah.
and the other UT will remain a UT.
UT. So carving out a UT is permissible, no?
But
According-
boundaries are,
Not from a state, I'm sorry. You can't
Boundaries are
create a
altered.
whole state as well.
boundaries are also.
Yes,
altered.
boundaries
Carving
are
out
also
a-
altered.
To that extent, yes.
So, Malad, this is all. And Malad, there is and I'm going to take your lordships of the Constitutional Assembly debates on this. Just presently, I'll do that.
And for J&K, consent is required.
Yes.